You're driving home. Blue lights flash in your rearview mirror. Your heart kicks against your ribs because you know what's in your center console. A legally owned pistol, properly stored, completely within your rights. The officer walks up to your window, and before you can even hand over your license, they ask you a question that could determine whether you drive away in 2 minutes or end up face down on the pavement with your car being torn apart. Do you have any weapons in the vehicle? What you say next isn't just conversation. It's a legal decision that 90% of gun owners get catastrophically wrong, and the consequences aren't just inconvenient, they're life-altering. This is about what happens when constitutional rights collide with traffic stops, when honesty becomes a trap, and when the very laws designed to protect you can be weaponized against you if you don't understand exactly how they work. What do you say when police ask about weapons? The answer isn't what you think, and what you don't know could cost you everything. Before we go any further, let me be direct about something. If this information matters to you, if you carry, if you own firearms, if you believe in understanding your rights instead of just hoping for the best, then subscribe to this channel right now, not later, now. Because what I'm about to break down is information that attorneys charge hundreds of dollars an hour to explain, information that could mean the difference between a routine traffic stop and a criminal charge. Millions of Americans are out there completely exposed, completely unaware that their instinct to be honest and cooperative is being used against them by a system that doesn't reward good intentions. Don't be one of them. Hit subscribe, turn on notifications, and commit to being informed instead of vulnerable. Last month in Ohio, a concealed carry permit holder, we'll call him Mike because his real name doesn't matter, what happened to him matters, was driving home from the range. He had his pistol locked in his center console. Everything legal. Valid permit, properly stored, following every rule. He gets pulled over for a broken taillight. Routine. The officer approaches, and here's where Mike's understanding of his rights collided with reality. The officer asks if there are any weapons in the car. Mike, thinking he's doing the right thing, thinking honesty and cooperation are the same thing, says yes. He explains he has a pistol in the center console. He's got his permit, he's legal, he's calm, and within 2 minutes, Mike is face down on the pavement, hands behind his back, watching multiple officers search his vehicle while he's treated like he just confessed to armed robbery. Mike didn't break a single law, but his answer triggered something he didn't understand, a legal mechanism that turns cooperation into vulnerability, that transforms a broken taillight into a felony-level response that takes your constitutional rights and uses them as leverage against you. This happens every single day in America. Not to criminals. To legal gun owners who think honesty is protection. It isn't. Knowledge is protection. When a police officer asks if you have weapons, they're not making small talk. They're conducting what's legally called a safety inquiry. And what that really means is they're building a framework for what happens next. Your answer, your honest, well-intentioned answer, creates something called probable cause expansion. That's not my term. That's what lawyers call it when your words give officers legal justification to do things they couldn't do before you spoke. Before you answered, it's a traffic stop. After you answer yes, it becomes a weapons investigation. The officer can now order you out of the vehicle. They can separate you from your passengers. They can call for backup. They can conduct a Terry frisk. That's a pat-down for weapons. They can, in many jurisdictions, search your vehicle. All because you told the truth. Not because you broke a law. Because you answered a question. Here's what makes this entire system insidious. In most states, you're not legally required to answer that question at all, unless you're in a state with what's called a duty to inform law. And only about 12 states have them. You have zero legal obligation to tell a police officer you're carrying. Zero. Read that again. Unless your specific state law requires you to inform officers that you're armed, you have a constitutional right to decline to answer questions about weapons. Most gun owners don't know this. They think the Second Amendment protects their right to carry. But they don't understand that the Fifth Amendment protects their right to stay silent about it. They think being cooperative means being confessional. But the law sees it differently. The law sees your answer as voluntary disclosure that creates reasonable suspicion, and reasonable suspicion is the legal threshold that opens doors you didn't even know existed. The Fifth Amendment isn't just about refusing to testify in court. It protects you from self-incrimination in any government interaction, including traffic stops. But here's the part that destroys people. The Supreme Court ruled in Salinas versus Texas that you have to actually invoke your right to remain silent. You can't just stay quiet and hope the officer understands. You have to say it. You have to clearly, verbally assert your right, or legally, it doesn't exist. That's why what you say matters so much. You can't just sit there. You can't mumble. You can't hope they move on. You have to use specific language that invokes constitutional protection, or you're just being uncooperative without legal cover, and that makes everything worse. Now, duty to inform laws complicate this. About 12 states, Ohio, Louisiana, Michigan, North Carolina, Texas, under certain conditions, and a few others, have laws that specifically require you to inform a police officer if you're carrying a concealed weapon, usually at the first moment of contact. If you're in one of these states, you don't have the option to decline. You have to inform. But even in these states, how you inform them, the exact words you use, the way you frame it, determines whether this goes smoothly or becomes a disaster. The law requires disclosure. It doesn't require you to volunteer information beyond what's legally mandated. It doesn't require you to explain your entire firearms history or justify your decision to carry. It requires specific information delivered in a specific context, and if you don't know the difference, you're going to give them everything when the law only asks for the minimum. Let's talk about the 3 mistakes that turn legal gun owners into suspects, because this is where good intentions meet terrible outcomes. Mistake number 1, over-explaining. People get nervous. Adrenaline hits. They start talking. Yes, officer, I have a gun, but it's registered, and I have my permit, and it's locked in the console, and I just came from the range, and I'm a law-abiding citizen, and my grandfather gave it to me, and I've never had any trouble. Stop. Every single word beyond the required minimum is a potential legal problem. You think you're reassuring the officer? What you're actually doing is providing a prosecutor with a transcript. You think you're being helpful. What you're doing is expanding the scope of the investigation. The more you talk, the more information you give, the more threads they can pull. You don't win legal battles by volunteering information. You win by understanding boundaries. Mistake number 2, lying. Some people panic when asked about weapons and say no when they're actually carrying. This is catastrophically stupid. If the officer finds the weapon later, during a search, during a pat-down, during any part of this interaction, you've now committed a crime in most jurisdictions. You've lied to a police officer. You've destroyed your credibility. You've turned a traffic stop into a criminal case where you're the defendant and the evidence is your own dishonesty. Whatever legal protection you had evaporates the moment you lie. Don't ever, under any circumstances, lie about whether you're armed. If you're not going to invoke your Fifth Amendment right to silence, then tell the truth. But lying isn't a third option. It's a guarantee of disaster. Mistake number 3, sudden movements. This one isn't just about legal consequences. This one's about survival. People get asked if they have weapons and immediately start reaching for their permit, pointing toward the console, trying to show the officer where the gun is located. Don't do this. Keep your hands on the steering wheel. Any sudden movement, any reach toward a hidden area, any gesture the officer interprets as threatening, and this situation can turn lethal in seconds. We've all seen the videos. We know how fast this goes wrong. Your job isn't to help the officer find your weapon. Your job is to keep your hands visible and follow instructions. If the officer wants to see your permit, they'll tell you how to retrieve it. If they want to know where the weapon is, they'll ask for specific information and tell you not to reach for it. Your hands stay on the wheel. Your movements stay slow and deliberate. Your words stay minimal. That's how you survive this interaction, not just legally, but physically. These three mistakes, over-explaining, lying, sudden movements, they're all products of the same problem. People don't understand that a traffic stop is a legal proceeding, not a conversation. They think they're talking to another human being who will appreciate honesty and cooperation, and maybe on a personal level, that's true. But on a legal level, everything you say is evidence. Everything you do is documented. And the system doesn't care about your intentions. It cares about what can be proven, what can be charged, what can be prosecuted. So, what do you actually say? 5 words. That's it. I decline to answer that. Simple, clear, legally protected, constitutionally sound, not combative, not hostile, not suspicious. Just a straightforward assertion of your Fifth Amendment right to remain silent on that specific question. Let me explain why these 5 words are perfect. First, you're not lying. You're not refusing to cooperate with lawful orders. You're not being difficult. You're exercising a constitutional right that exists specifically for this purpose, to protect you from self-incrimination, even when you haven't done anything wrong. The Supreme Court has repeatedly upheld your right to do this. In Salinas versus Texas, the court made it clear, you have to invoke your right to silence. You can't just stay quiet. You have to say it. These 5 words do exactly that. Second, these words don't give the officer additional ammunition. You're not admitting to having a weapon. You're not denying it. You're creating what lawyers call legal ambiguity. The officer can't use your answer as probable cause because you didn't give them an answer to use. They asked a question. You declined to answer. That's not suspicious. That's constitutional. Third, it's respectful. You're not saying that's none of your business or I don't have to tell you anything in some aggressive, sovereign citizen tone that escalates everything. You're using professional language that demonstrates you understand your rights without being hostile about it. And here's something most people don't realize. Most police officers actually respect people who know their rights and exercise them calmly. They deal with people who don't know the law all day long. Someone who clearly understands the legal framework and exercises their rights without drama often gets more respect than someone who just word vomits everything out of nervousness. Here's how this plays out in practice. The officer walks up to your window. You hand over your license and registration. Your hands are on the steering wheel. You're calm. The officer asks, "Do you have any weapons in the vehicle?" You look directly at them and say, "Officer, I decline to answer that question." Then you stop talking. You don't explain. You don't apologize. You don't fill the silence. You just wait. The officer now has 3 options. Option 1, they accept your answer and continue with the traffic stop as normal. This happens more often than people think, especially if you're calm, respectful, and clearly exercising a right rather than being evasive. They write you a ticket for whatever you were pulled over for, you sign it, you leave. Total time, 5 minutes. Option 2, they ask why you won't answer. If this happens, you don't get defensive. You don't explain your legal theory. You simply repeat, "I'm exercising my right to decline to answer that question." That's it. You're not arguing. You're not lecturing. You're just reasserting the same constitutional position. Option 3, they order you out of the vehicle for officer safety. This is where people panic, but you need to understand something critical. You can decline to answer questions, but you cannot refuse lawful orders. If an officer orders you out of the vehicle, you comply immediately. You step out, you keep your hands visible, you follow every instruction, and you still maintain your right to silence about weapons. Getting out of the car doesn't mean you've given up your Fifth Amendment protection. You can stand there, hands visible, and still decline to answer questions. The officer might conduct a Terry frisk, a pat-down for weapons. That's legal if they have reasonable suspicion for their safety. But here's the critical part. They still can't search your vehicle without probable cause or your consent. Your silence alone is not probable cause. Declining to answer a question is not reasonable suspicion. They need something more. Now let's talk about duty to inform states. Because if you live in one of these 12 or so states, the 5-word response doesn't apply the same way. You're legally required to inform the officer that you're carrying, but you can still control how you do it, and that control is everything. Here's the script. Keep your hands on the steering wheel. Before the officer asks anything, you say, "Officer, I'm required to inform you that I have a valid concealed carry permit and I'm currently armed. My weapon is in the center console. My permit is in my wallet. How would you like me to proceed?" Notice what you just did. You fulfilled your legal duty to inform. You told them where the weapon is, so they're not surprised if they see it. You told them you're legal, you have a permit, and then you put the control back on them by asking how to proceed. You didn't reach for anything, you didn't make sudden movements, you didn't over-explain. You gave them the information required by law and nothing more. This approach works because it demonstrates you understand both your obligations and your rights. You're not hiding anything, you're not being evasive, but you're also not volunteering your life story. You're giving them what the law requires and letting them direct the next steps. Most of the time, the officer will tell you to keep your hands on the wheel, they'll retrieve your permit themselves, or they'll ask you to slowly reach for it with 2 fingers. They might ask you to step out while they secure the weapon temporarily. All of that is fine. You comply. You stay calm. You don't argue. And in most cases, this ends with a ticket or a warning, and you drive away. The difference between this going smoothly and this becoming a nightmare is understanding the exact boundaries of what you're required to say. Let me give you 3 scenarios where the 5-word response protects you because this isn't just about traffic stops. Scenario 1, you're at a DUI checkpoint. They're stopping every car. They ask about weapons. You're completely sober, you're completely legal. But if you say yes, even though you haven't done anything wrong, you might get pulled aside for additional screening. Why? Because you introduced a complication into what's supposed to be a quick interaction. The 5-word response keeps things moving. You decline to answer. You pass through. No drama. Scenario 2. You're traveling through a state you're not familiar with. You're carrying under reciprocity from your home state permit. The officer asks about weapons. Here's the problem. You're not 100% sure if your reciprocity is valid in every location within this state. Some states have municipal exceptions, some have specific prohibited areas. If you admit you're carrying and it turns out there's some obscure reciprocity gap you didn't know about, you just confessed to illegal carry. The 5-word response protects you from incriminating yourself based on complex reciprocity laws you don't fully understand. Scenario 3. You're pulled over with a passenger in your car, and that passenger has a weapon. The officer asks if there are weapons in the vehicle. If you say yes, you might be taking legal responsibility for someone else's gun. If you say no, you're lying. The 5-word response protects you from both traps. You're not responsible for disclosing what your passenger is carrying. You're only responsible for yourself, and even that's limited unless you're in a duty to inform state. Here's what almost everyone gets wrong about police interactions. They think cooperation means answering every question. It doesn't. Cooperation means following lawful orders. Those are 2 completely different things, and if you don't understand the difference, you're going to give away rights you don't have to give away. A question sounds like this. Do you have any weapons? Where are you coming from? Where are you headed? Do you mind if I search your vehicle? These are voluntary. You can decline to answer. An order sounds like this. Step out of the vehicle. Keep your hands where I can see them. Give me your license and registration. These are not voluntary. You must comply. The entire legal framework hinges on this distinction. You have a right to remain silent. You do not have a right to disobey lawful orders. Know the difference and you'll navigate these interactions successfully. Confuse them, and you'll either give up rights you should protect or refuse commands you're legally required to follow. Both outcomes are bad. Understanding the line between them is how you protect yourself. And let me tell you what not to say, because there are phrases that make everything worse. Don't ask, "Am I being detained?" right at the start of a traffic stop. You are being detained. It's a traffic stop. That's a detention. Asking that question makes you sound like you watched too many YouTube videos and you're trying to play lawyer. Don't say, "I know my rights," in an aggressive tone. That's confrontational for no reason. Your rights speak for themselves when you exercise them calmly. Don't immediately bring up your lawyer unless you're actually being arrested. If you're just being questioned during a traffic stop, saying, "I want my lawyer," can escalate things unnecessarily. Save that for when you're actually facing criminal investigation. And don't start recording the officer without informing them in states that require two-party consent for recordings. Know your state's recording laws before you pull out your phone. All of these tactics can turn a manageable situation into a confrontation, and that's not protecting your rights. That's feeding your ego. Here's what you need to do right now, today, before you ever need this information. First, look up whether your state has a duty to inform law. Go to your state's legislature website or a trusted gun law resource. Don't guess. Don't assume. Know your specific state requirements, because if you're in a duty to inform state and you don't inform, that's a crime. Second, practice saying those 5 words out loud. I'm serious. Say them in your car. Say them in front of a mirror. Get comfortable with the language so it comes naturally when your adrenaline is spiking and your heart is pounding. Under stress, you default to what's familiar. Make these words familiar. Third, if you're in a duty to inform state, memorize the script. Practice it until you can deliver it calmly and clearly without thinking. Fourth, keep your documents organized. License, registration, insurance, carry permit if applicable. Have them accessible without reaching into hidden compartments or glove boxes that might make an officer nervous. And here's something nobody talks about. Keep a card in your wallet with your attorney's phone number, not because you're planning to get arrested, because if things escalate beyond a traffic stop, if you're asked to come to the station, if you're being detained for investigation, that's when you say, "I want to speak with my attorney," and you hand them that card. Having the number ready isn't suspicious, it's smart. It shows you're serious about protecting your rights, and that matters. The 5-word response works for traffic stops, but what about other situations? What if you're open carrying and someone calls the police on you? What if police knock on your door at home? The principle stays the same. You have the right to decline to answer questions, but the approach adapts. For a home visit where police are at your door, you might say, "Officer, I'm not answering questions without my attorney present." You don't have to let them in without a warrant. You don't have to explain yourself. For an open carry encounter in public, you might say, "I'm exercising my Second Amendment rights, and I'm not answering questions." The key is understanding that your constitutional rights don't change based on location. What changes is the tactical situation and the authority officers have in different contexts. In your home, they need a warrant or exigent circumstances to enter without your permission. During a traffic stop, they have more authority because of the inherent mobility and safety concerns of a vehicle stop. Knowing these differences helps you navigate each situation appropriately without either giving up rights you should protect or refusing authority they legally have. Let me bring this full circle. When a police officer asks if you have weapons, your answer needs to be strategic, not emotional. If you're in a duty to inform state, you inform them calmly, hands visible, and you ask how to proceed. You fulfill the legal requirement without volunteering information beyond what's mandated. If you're not in a duty to inform state, you have the right to decline to answer, and you do it with 5 words. I decline to answer that. You stay calm, you stay respectful, you stay silent on anything beyond what's legally required. You follow lawful orders immediately, and you never, under any circumstances, lie. This approach protects you legally while maintaining a respectful interaction. It prevents you from accidentally incriminating yourself over laws you don't even know exist. It keeps the encounter from escalating unnecessarily. And it preserves your rights for anything that might come later, because here's the reality. Once you give information, you can't take it back. Once you answer questions, those answers become evidence. Once you consent to a search, that consent is on record. Your silence protects your future options. Your words eliminate them. If you've made it this far, you understand something most gun owners never learn. Rights aren't automatic protections. They're tools you have to know how to use. The Second Amendment gives you the right to carry. The Fifth Amendment gives you the right to protect yourself legally during encounters with law enforcement. But neither one works if you don't understand how to invoke them. This channel exists to close that gap, to give you the information that keeps you safe, keeps you legal, and keeps you from becoming another story about a legal gun owner who got destroyed by the system because they didn't know the rules. Subscribe right now if you want to stay ahead of this. Turn on notifications. Share this with every gun owner you know, because this information could save someone's freedom. Don't wait until you're the one sitting in a car with blue lights behind you, trying to remember what you're supposed to say. Get informed now while you can think clearly. Hit that subscribe button. Remember Mike from the beginning of this story? After what happened to him, after the pavement, after the search, after the humiliation of being treated like a criminal for following the law, he learned exactly what I just taught you. The next time he got pulled over, he was ready. The officer asked about weapons. Mike kept his hands on the steering wheel, looked at the officer calmly, and said, "Officer, I decline to answer that question." The officer nodded, finished writing the ticket for the broken tail light, handed it to Mike, and sent him on his way. Total interaction time, 4 minutes. No drama, no search, no face on the pavement. That's the difference knowledge makes. That's the difference between understanding your rights and hoping for the best. Mike's first encounter was a nightmare because he didn't know what you now know. His second encounter was routine because he did. The only variable that changed was information. Everything else, the law, the officer's authority, Mike's rights, all of that stayed the same. What changed was Mike's understanding of how to navigate the interaction, and that made all the difference. That's what this information does. It changes outcomes. It protects you when good intentions aren't enough. It gives you the framework to handle situations that most people stumble through blind, hoping they don't accidentally say something that destroys their life. You now have that framework. You know the 5 words. You know when to use them and when you need to inform instead. You know the difference between questions and orders. You know the mistakes that turn cooperation into incrimination. Use this knowledge, practice it, internalize it. And for the sake of everyone who carries, everyone who believes in the Second Amendment, everyone who thinks constitutional rights matter, share this information, because the system isn't going to teach people their rights. That's on us. That's on channels like this, on viewers like you, on communities that refuse to let ignorance be the default setting. Subscribe, stay informed, stay protected, and remember, your rights only work if you know how to use them.